Welcome, everybody. I'm going to start sharing my screen. So you should be able to see my screen. We have Homer and on our screen, and you can see the family tree. You're well aware of those things. So we're going to concentrate on this tab here, the provisions tab. And that's going to handle certain decisions that we want to make throughout the will. Things that might not deal with gifts so much as more general provisions. So that's why they're in their separate tab. So let's deal one by one with these. So the first, obviously, element is funeral arrangements, burial arrangements, whatever kind of end of, after death kind of disposition of the body kind of thing. And you kind of have two choices. One is, I think it comes up with, I desire my body be like that as a default. And you can do a couple of things there. You can either eliminate it completely so that it's empty. And if that's the case, then the disposition of the body section in the will not print at all. So it won't have a title and it won't have any content. And that's what you can do if your client doesn't want to make any funeral arrangements in their will. On the other hand, if you want to do something or put some kind of clause in there, you can obviously add on to what you had there, a desire that my body be, cremated, for example, and then you can obviously paste if you have some standard language that you prefer, that you use regularly, you can just paste it in here and it'll automatically print in. So that's one of the benefits of, of this box is I'm just gonna, you can just cut it from another document, paste it in here. If there are, if you guys have suggestions on certain standard options that you'd like, let us know, because we're going to build this out a little bit to have more customizable options that you can pick from your list of different options, and then it'll put it in. But for now, it's you just manually put in whatever you want and it will populate. So that is funeral arrangements. Let's talk about future members. So these all deal with who is going to get included in the definition of a class. And so right now we kind of deal with 4 that we think are the most likely. And again, feedback we always like. So children, if you've got a client with young children, for example, there will be a warning. So if eState sees that you have that the client has young children, it's going to give you a warning to consider including future children provision. In other words, ask the client, do you want this will to only refer to your current living children, or do you want them to include future children? And if we wanted that to be the case, if we wanted to include future children, then we would just click that button. And I'll show you in a moment what the impact of that would be. But basically, it says when it talks about who my children are, it would list the children that you currently have and any other future child that's born or adopted to the two of you, to you and to Homer and Marjorie, the spouse. That's how it would work. And we have similar provisions for grandchildren, nieces and nephews, and spouses, nieces and nephews. So when you look at the people tab, so if you were picking, for example, children as beneficiaries, I'm just going to show you the impact of that. So if we were picking the children as beneficiaries, if you see the 3+ number, the plus means that it's including future members. So that's why that's how you know if future members are included. If we didn't include it, it would just say 3 members. Okay, so that's the idea on the future members. And of course, that would include when you're dividing it among your children, then it would be my children and who are living at the date of my death, in essence, or whatever date you're picking. So that's what we've got there. So that's the impact of including future members. It's again the class definition. So then we have class restrictions. So we've got some feedback on this, and I'd like to get your feedback as well from the group here. But right now we have, let's just talk about children born out of wedlock. So if we, we have two options, right? So if we include children born out of wedlock, it says we're excluding all children born out of wedlock except a child who is treated as a child, okay? So we have a modified definition of include children born out of wedlock. We don't include any child born out of wedlock. They have to be at least acknowledged as a child. What we're getting some feedback from people, and please share this in the chat or otherwise, would you want the option to exclude all children born out of wedlock, include all children born out of wedlock, whether they were known about or treated as a child or not? Because right now we don't support that option. So if that's something that people want, we can obviously deal with that. And that is the default rule. So if we built that option, all that would happen is we would get rid of any reference to excluding anyone, any child. So that's the idea. If we uncheck that, that's going to exclude every child born out of wedlock. So they're going to be excluded, even if they were treated as a child, they're going to be excluded. So that's why typically I'm going to use include children born out of wedlock, because I want a child who was born to a common law relationship to be counted as their child if they treated them as a child, right? They knew about them, for example, et cetera. So that's the idea there. And what I'll do is I'm just going to generate a will while we're talking here, and show you the definition so you can see that. So that's the children born out of wedlock. And again, if people have a use case for that, then you'll let me know and we can show that. Okay, so then what we've got is this option for posthumously conceived children. So about, I don't know how many years ago it is now, I'll say 5 years ago, our law started to include children who were conceived after death of the parent, in essence, using their genetic material. And so we have the choice of either including those people who are conceived after death or excluding them. I often just exclude it. I'll ask the client, do you want to include these people that are conceived after the death of someone else or not, and get their instructions, and either we'll include it or exclude it. The difficulty with those kinds of issues is, class closing rules and such things. So in eState, if you include them, we put in a definition that says if they're conceived and born after the date of death, they're to be deemed to have been born at the date of death for the purposes of the distribution of the estate. And so we deal with that. So I'll deal with questions in a second. So that's where we have on the class restrictions, and I'll generate, let's just see, I'll generate we have a new will coming out. Maybe I'll generate, I'm going to generate a multiple will with this. Give me 1 second. In the wrong spot. Here we go. Okay. So let me just generate multiple wills. We had a question about if the client instructs you to not to include future children, could you put in the will notes that such is the case to alert the clients? Yeah, I mean, I would certainly speak to them about that, and I'm not sure I'd put it, well, in my will notes, yes, absolutely. I would put it in my will notes for sure. So yes, and remind the client. And in fact, it's something that that you want to make sure that you've noticed and identified that they don't want to include future children. So let me just stop here for a second and just pull up the will, just so we can just pause here and I can show you what, and I'm doing it in multiple wills, but single wills would work the same. and I'll just go to the class. So this is the definition of children, and I'm just going to make it a bit bigger here. So because I included future children, eState names the children specifically, but then adds and any other child born to or adopted by both parents. Okay, so that neither has to worry that it's a child that the other one has that didn't include their spouse. So that's what we do with that. I just also want to then show you the idea of this is if we're including children born out of wedlock. So what our definition says is it requires that they be related by blood. So they have to be, they can't be a stepchild. They have to be related by blood or adopted, but does not include a person born outside of marriage, except subject to this paragraph below, which is this idea where they've demonstrated a settled intention to treat the child as his or her child. So that's the drafting if you're including children born out of wedlock. And again, if we can build in the option if you wanted an option where it included every child born out of wedlock, whether they were treated as a child or not, you could just simply delete this paragraph because by law they would be included, right? Our law includes that. So then we have this is if we're including posthumously conceived children, then we're talking about somebody who includes a child who is conceived or born after the death of his or her parent, such child being deemed to be born alive at the death of the parent. So that's the idea there. And that makes it a little bit easier when you're interpreting the will for anti-lapse and other reasons. So that's what we have there. All right, so the next section of the provisions is trusts for beneficiaries under a certain age. This is a general trust clause that gets populated in eState to cover any people under whatever age you pick, and to have a trust pop up and hold money for them, even if you haven't drafted a specific trust in eState for them, okay? So that's what the purpose of this is. And most often it's used for remote issues. So you might have a trust, for example, for children that you create in eState using your trust component with a gift over to their issue. Well, if their children are young, if they predecease or die before that age and have young children, we need a trust for those younger grandchildren. And so that's what this trust for beneficiaries under a certain age does. So let me see, I guess I have it here. Let me just show you what that section looks like. We call that, our short form in-house is called BUCA, for beneficiaries under a certain age, but that's this clause. So it says, if, obviously if there's a specific trust for a person, then use those terms for that trust. But if there's a gift to a person that doesn't have a trust set up for them, and they're under the age of 28 in this case. Now, 28 was what I set here. You can set this at any age that you like, okay? So that's just going to pick up from that age. So while under the age of whatever age, then there's a trust that pops up. And that's what this creates. And you can even create an interim distribution for these general trusts. Right now, we allow one interim distribution. We don't have the full multiple staged, mostly because me personally, I didn't think we needed it for a general trust. If we wanted a more complicated trust, we'd probably want to just create a specific trust for that group of people. But we have heard from some other firms that they would like to have multiple interim distributions in this general trust clause. And so we're going to build that. But that's the idea. So that's the beneficiaries under a certain age. And again, it's always going to appear as long as an eState sort of knows what's out there. If there's a gift over to remote issue, it's going to put in this beneficiaries under a certain age clause. If everything's going to charity, it knows that there's nobody who could be under a certain age, and therefore it wouldn't print this. So that's the idea. But as soon as it sees, the clause will not disappear ever. Sorry, there's a question here from Lindsay. If you leave the age blank, will the clause disappear? No, it won't. It'll just print a blank age, mostly because we want to have some clause in there to deal with people who might inherit at a certain age. If it's going to be 18, if you want them to get it at 18, then I would still put in a clause. I would still use this beneficiaries under certain age clause in any event. So that's why. No, there's a then there's a question. Would it make sense to have BUCA clause after the ultimate distribution clause, so that if the had BUCA, it would pick up it chronologically? What we do is we like to keep all the dispositive provisions together. So we do the ultimate distribution, but then we reference the BUCA paragraph here. So after giving effect to the foregoing plus BUCA, where I have no spouse, because the reality is this often the most relevant, the clause is relevant because of the distribution in the ultimate distribution. If everyone's gone, I want to give it to siblings. And if siblings who are the same age as the parents often are predeceased, I want it to go to their kids, so nieces and nephews. That's often when we need this beneficiary under a certain age. And so that's why we place it after all the dispositive provisions. So there's no problem. There's just a question. If I change that to age 30, there's no problem with that, right? You can set this at any age. Obviously, this is going to cover any gifts to anyone under that age, except where you have made a provision for specific people to specific trust provisions for another beneficiary. That's that. So that's the idea. That's the beneficiary under certain age. And if you think that there should be some situations, even where you could have minor beneficiaries where it should not appear. Love to hear that. So if you want to send me a note or whatever, I'd love to explore that and see if take some feedback on that. Personally, I don't see that we would want that, but I'd love to hear the other view for sure. So then we've added this loan forgiveness in the last few months. This is where you want to forgive non-arm's length loans. Non-arm's length loans are typically, spouse, children issue, children's spouses, and we have another category. So if you do this, what's going to happen is it's going to put in a clause that says, I hereby forgive any loans that I've made to my spouse or my children, et cetera. And so that's what's going to get generated. And again, you could have all categories. You could forgive everybody. Remember, again, we want non-arm's length loans sort of explained rather than just leaving it, I forgive all loans, because you may not want to forgive all loans. You may have somebody who owes you money that you want to collect on. So that's why we have this clause, but it's limited to non-arm's length loans. Of course, if you want to forgive some other loans, then you have to do that specifically and manually, actually. In eState, if that's the case. So that's the general forgiveness. I'll just show you kind of what you might do here. I'll just generate a will here, and we can go back to that in a second. So then what we've got here is now the secondary will asset. So everything up to this point is applicable for all wills. Okay, the secondary will assets, and we're going to move these eventually to another place, so they're only to deal with secondary will. But what these are what you're picking here are definitions. So let me just, before I go there, I'm just going to show you the forgiveness of loans. Let me just do this. So I'm just going to forgiveness of arm's length loans. So this is what the clause that would get populated in this, if you forgave the loans. Right, that's the forgiveness clause. So then we're going to the definitions section now of the multiple wills. That's what this secondary will assets section does. It's what definitions are going to be included in the secondary will. And by default, I believe, and I'm not 100% sure, but I think by default, and again, you can set your defaults, but I think we don't include non-arm's length by default. We don't include other lives, life insurance. We don't include partnership interest. But the idea here is that, typically you're going to exclude personal effects from the primary will and deal with it in the secondary will. You're going to typically exclude specifically named corporate assets, as well as unspecified corporate assets. What do I mean by that? Those are, let me just show you what I'm talking about. Those are the basket clause that covers, so specifically, so specifically named assets are here. And what that does, eState, if we include that, is it pulls any private company shares that are owned by either spouse and puts them in the definition of corporate assets. Why do we pick it from both spouses? Well, it's possible that the surviving spouse may inherit those shares, and so we want them to be covered by the definition if indeed they do end up owning those shares on their death. And if they don't, they don't. It's not a big deal but it's just really the definition. And the unspecified are defined here. So, and this is any other private corporation that I control or my spouse. In this case, we picked spouse control. So that's the unspecified. And we use this definition, and you can, if you don't want to use it, of course you can edit it. But we use that definition because we don't want to try to deal with, in the secondary will, minority interests in private companies that might end up needing probate to deal with. So that's why we use, if we're going to use a basket clause, we're going to want it limited. So that's why we do that. Then registry system real estate, trust assets, trust loans, and I might want to include all of them in the definition. And therefore, that's what eState would do. It would include in our definition section all of those different things: trust assets, registry system real estate, that's mostly now first dealings exemption properties, trust loans, which are amounts owing from any trust, other lives, life insurance is a policy of life insurance, which I own, the testator owns, but it's payable on the death of some other person. So the life insured is somebody else. So that's what we've got there. And of course, the definitions of the sections of the different estates automatically catch all of those definitions. So you don't have to worry that one's not covered. And that's the purpose of the provisions section. As sole proprietorships are basically no different than, the question was, are sole proprietorships covered? Well, sole proprietorship is really nothing. It's owned by the testator, so typically wouldn't be in the secondary will. So that's why we don't typically do that. One of the things we're going to have is the ability for you to add additional categories that automatically get added. And you can, for example, if you want to add, for example, sole proprietorships as an asset that's governed by the secondary will, you could do that and then add in the definition for that. But right now you're kind of limited to what we've got as it stands. So that is what I wanted to cover about the provisions tab. Wanted also to share with you a brand new element that and function. So in secondary wills, in multiple will situations, we've heard from a lot of people that they do not like the fact that private company share gifts appear in both wills. They want them only to appear in the secondary will. Or whatever that, and I completely understand that. It's what people are most comfortable with. So as long as those private company shares all end up in the secondary will, it'll be fine. But what we've done is to allow for that. If you go to your multiple wills and you go down to gift options, there's an option for private company shares. By default, it's going to do the same thing as it's always done. That is, print a private company share gift in both primary will and secondary will. But you also now have the option to go secondary will only. And if you do that, then the gift of private company shares will only appear in the secondary will and will not appear in the primary will. So that is a function that people have asked us for. And you can set that either when you're generating a particular will for a client. Of course, it's only relevant if you're giving us a specific, you're making a gift of a private company share, right? That's when this is relevant. When you make a gift of a private company share to someone, that's when the choice of do you want it to appear in both primary and secondary will or only secondary will becomes relevant. So that option is available both when you go to generate a will for a client, or you can set it as your default. If you never want it to be appearing in the primary will when you give away private company shares, gifts, then you can set that as your default, and it will by default do that, and you can override it if you ever wanted to when you generated the will. So the question was, so I just want to deal with this one question. Is there a disadvantage to having a private company share appearing only in the primary, will? The issue is that I don't think there's any problem with it in the drafting, because we say in most cases those private company shares are going to be in the secondary will because they can be transferred without probate. The only problem about putting it only in the secondary will is if those shares ever needed probate and needed to be put into the primary will, the gift doesn't exist in the primary will. So you have a disconnect between the gift, which is in the secondary will, and the asset, which is in the primary will. And that's why we make the gifts in both wills. So that's the idea. Posthumously conceived children is after death. So the child is, the law has always been if the child is conceived before death, but born after, they were always a child. What this new law is a posthumously conceived child. So a child who is conceived posthumously. So, so that's that. Any questions? We have Thursday coming. Thursday, we're doing part 2 of our constructive and resulting trust presentation. Ian and I are going to work on that one and do that on Thursday. We also are going to talk about a really interesting first kind of substantial compliance case out of Ontario dealing with an unsigned will. So hope you guys can join us on Thursday, and keep your comments and suggestions coming, and we look forward to it, and see you again next week, if not on Thursday. Bye-bye now.